Did you pay more than two $500 payments, Ms. Hernandez? Don't lie to me, because I'm going to get to the bottom of this. Listen to
Yes,
me very
I
quickly.
paid two on the day at the Secretary of
I
State.
didn't ask you that. Hang on a second. I want to be clear. I don't want anybody lying to me, and I'm going to find out who's lying.
On February 10th, 2026, a civil dispute was heard in a Michigan courtroom involving Leslie Bazur and Cynthia Hernandez over an unpaid car debt. The case centered around a private vehicle sale that had gone terribly wrong. Ms. Bazur had sold her car to Ms. Hernandez for $3,000 with a payment plan of $500 per month over 6 months. The agreement, signed on October 2nd, 2025, outlined that payments would begin on October 1st with the final payment due on March 1st, 2026. Ms. Hernandez made the first two payments totaling $1,000, which both parties initialed as proof of payment. However, after November 5th, 2025, Ms. Bazur claimed Ms. Hernandez stopped making payments entirely, leaving a balance of $2,000. What made this case particularly troubling was that Ms. Bazur had already signed the car title over to Ms. Hernandez before receiving full payment and had failed to list herself as a secured party on the title. This meant that Ms. Hernandez now legally owned the vehicle despite claims that she's owing half the purchase price, and when the parties appeared before the judge, what should have been a straightforward case would quickly evolve into one of the most blatant cases of perjury the judge had witnessed in over 3 decades on the bench.
Boy, you didn't do a very good job on this, ma'am. You can't be doing this. Your name?
Leslie Bazur.
Your name?
Cynthia Hernandez.
Why don't you come up here? I want you guys to resolve this. Did you buy a car from her?
Yes.
Did you stop
paid
making?
for. I have the title.
Hang on. Did you stop making the payments?
No, the car is paid for in full.
Is that true? Did she pay for it in full?
No, Your Honor. In the contract, it states,
Do you have a security agreement? I was concerned about this. You didn't have a security agreement, did you?
no, my name was supposed to be on the title.
You guys, you try to be your own lawyers. It'd be like me. I don't care if she was your friend, not your friend. You guys can't do things like this. This was a recipe for a disaster. Your name's supposed to be on the title of somebody else. When they're driving, they're going to be coming after you. Ms. Hernandez,
Yes.
did she pay the payments?
No.
Good. Then
This is the last payment to be made on March 1st.
Well, what if she paid in advance? Did she pay in advance?
2 $500 payments.
Did you pay more than two $500 payments, Ms. Hernandez? Don't lie to me, because I'm going to get...
The judge immediately sensed something was wrong with Ms. Hernandez's story. When Ms. Hernandez claimed she had paid more than the 2 documented $500 payments, the judge warned her not to lie. Under Michigan law, specifically MCL 750.422, perjury is defined as willfully making a false statement under oath in a judicial proceeding. Perjury is a felony punishable by up to 15 years in prison. What the judge recognized at this early stage was a classic pattern of witness testimony that doesn't align with documented evidence. Experienced judges develop an instinct for detecting dishonesty, often through inconsistencies in the story, defensive body language, or attempts to provide vague answers to specific questions. Here, Ms. Hernandez's claim that she had made additional payments beyond the 2 documented ones immediately raised red flags, especially since the original payment agreement clearly outlined a 6-month payment schedule with specific dates. If additional payments had been made, there should have been corresponding documentation, or at minimum, initials from both parties, as had been done with the first 2 payments. The judge's warning at this point was not merely procedural. It was a final opportunity for Ms. Hernandez to reconsider her testimony before committing perjury on the record.
Yes,
Very
I
good.
paid two on the day at the Secretary of
I
State.
didn't ask you that. Hang on a second. I want to be clear.
Okay.
I don't want anybody lying to me, and I'm going to find out who's lying. If she's saying it's not paid and you're saying it is paid, one of you are lying to me. So if you want to come up here with all your documentation and I'll try to resolve this for you guys right now, that would be fantastic.
On September 12th.
Hang on. I didn't say that. I didn't say anything here. Why don't you get dressed and come on up here? You live on Riverside, right?
Yes.
It's only a 6-8 minute drive at best. Bring all your documentation that tells me that you've paid for the car. How much do you think is owed?
2,000
How did she pay on the first 2 payments?
cash.
Nice.
Right.
Really good.
We were
Really,
together. She was living in my house.
really, really, really good.
Yeah.
Did you give her a receipt?
Well, I wrote
Did you give her a receipt?
I wrote in this book.
Did you give her a receipt?
No, you're
You
on.
guys, you know what? I mean, bring all your documentation up here right now, Ms. Hernandez. So you guys, she was supposed to put your name, keep your name on the title, huh? Did you sign did you sign the title over?
I didn't.
Why would you sign the title over before you? It'd be like you tell me you're gonna buy my house and I sign, hang on, well, then you should have talked to a lawyer. That's what they do.
Right.
That's what they do. I never sold it before. Come on up here, Ms. Hernandez. We're resolving this morning. Get yourself dressed. She's gonna wait, and you come on up here. How long will it take you?
Say, I don't know, 40 minutes.
I'll see you about 10 o'clock. Don't hurry, don't rush. I don't want you getting in an accident.
Right,
Take your
right.
time.
Okay.
I hope you're never gonna do something like this again.
Absolutely not. It's unfortunate.
This pains me to see this. It really does. I know it's only $2,000, but $2,000 is a lot of money. Bring all your documentation that shows me she paid you. You paid her. If you took cash out, you can go to the bank.
I had
Wait.
cash. I don't.
Wait,
I,
ma'am, Ms. Hernandez, I'm going to find out who's lying to me. It doesn't matter to me who's lying. I'm going to, ma'am,
With that too.
I'm going to find out who's lying. You guys just make this hard when you do this, like with a handshake.
My mistake.
You didn't make a mistake. You don't have to apologize to me. You might be out when it's your burden of proof here. But I can tell somebody's lying, and I'm going to tell you who it is when we get here. Bring all your documentation, Ms. Hernandez, okay? That tells me that you paid this. Guys, I mean, you say you have a security. You filed a pleading saying you have a security agreement. Do you know what a security agreement is?
I was going by what
The
the
big-
lawyer told me to write down.
Don't tell me what the lawyer told you. That's between you two. If I went to a bank or I went to a dealership and bought a car, that's when I will execute a security agreement. I doubt that you had her execute a security agreement. Why'd you allege it in the complaint? Shh. Give me all your documentation. Did you ever sign a note at least?
We had this agreement that I gave you a copy. You should have a copy of our contract.
Okay.
And she signed for the 2 payments that she did give me.
She signed?
She signed, yeah. The 2 payments, one on,
Oh, man, that's kind of telling, Ms. Hernandez.
and it says in the
You
contract.
guys come up here. Come on, get dressed. Come on up here. But I'm telling you, I'm going to have you guys under oath, and I'm going to resolve this today, and you guys are going to...
30.
Perfect. 8:30. You guys be here. Don't make me wait.
The judge made the strategic decision to have both parties appear in person with all their documentation rather than resolve the matter immediately over Zoom. Apart from the growing suspicion that the plaintiff, Ms. Bazier, might as well be trying to pull a scam, as it's very unlikely anyone would sign off their title without receiving full payment, this decision reflected an important principle in civil procedure: the burden of proof. Under Michigan Court Rule 2.116, the party bringing the lawsuit, in this case Ms. Bazier, bears the burden of proving her claim by a preponderance of the evidence, meaning it's more likely than not that the defendant owes the money. However, once the plaintiff establishes a prima facie case by presenting the signed payment agreement and documented payments, the burden shifts to the defendant to prove additional payments were made. The judge recognized this was going to come down to a credibility determination and wanted both parties present with all documentation so he could examine the evidence thoroughly and observe their demeanor while testifying under oath. However, it wasn't until the next day that Ms. Hernandez showed up in court.
Let me just read something that's attached. No, you did actually draft something here. I don't know who drafted this for you, Ms. Bazier, but I could make a case that this is a security agreement. I'm gonna do this a little different. Now, before we go on, I'm gonna scare everybody to a note. And I'm gonna try to do this a little different. But I want you to know you're under oath. I'm gonna ask both of you to raise your right hands, please. You solemnly swear or affirm under penalties of perjury that the testimony you will give at these proceedings will be the whole true self you got. Ms. Bolsinger, Ms. Hernandez?
Do.
Let me see the proof that you have that you made the payment. She attached to her complaint documentation that does spell out that you were to pay $3,000, and there was a payment made on October the 2nd that you, by the way, initialed of $500, and again on November 5 of $500. Do you have any more documentation that indicates that you made any other payment?
What I have.
Let me see what you got.
The two that right there, and then stack. Not the front, that's her.
Whose writing is this in?
Not writing. And then on the back is what you was right.
Oh, wait a minute.
Those are my notes, and then.
Ma'am, on the first two payments, you guys both initialed the $500 payment. And then you just added $2,000 paid on September 25th that you wrote on the back of this, right?
That was the notes I kept from the day that we put the car in my name. The day that Secretary of State that I gave her money. That's when the title that I had went into my name. She kept notes, I kept notes. Oh, I wrote a contract. Can I speak, Your Honor?
Now, I want to know if that's your story and you're sticking to it because you're under oath. This is going to be easier than I thought.
Before allowing testimony to proceed, the judge administered an oath to both parties. This formal swearing in is a critical moment in any court proceeding. Under MCL 600.1432, witnesses in Michigan courts must take an oath or affirmation that they will testify truthfully. The oath serves multiple purposes. It reminds witnesses of their legal and moral obligation to tell the truth. It establishes the foundation for potential perjury charges if false testimony is given, and it creates a formal record that the witness was aware of their duty to be truthful. The judge specifically stated, "You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth. So help you God." This language is significant because it explicitly references the penalties of perjury, putting both parties on notice that false testimony carries criminal consequences. Soon the judge proceeded to check the documentation, but when he did, he immediately identified a fraud, prompting him to confirm both parties' stories given they were under oath. His comment, "This is going to be easier than I thought," signaled he'd already identified the lie and recognized this as a clear-cut case of fabricated evidence.
Are you telling me you paid her $2,000 on September the 25th?
Yes.
How'd you pay the did she pay you $2,000 on September 25th?
Your Honor, absolutely not. She didn't have the money. She had to bail herself out of jail. That's why I offered her my college.
Come up in front of my report. Show her that document. Did you ever see that page?
No.
I neither. Ms. Hernandez, who do you think that you are coming in here and trying to...
What?
Put that back. Give me that back, please.
Hostile business.
Who do you think you are coming in here with notes on the back of that document?
That is horrible.
Expecting me to buy this. And now you come in here defiantly and no, I don't want to talk. I don't care if you talk. You owe her $2,000 at minimum, okay? How are we going to resolve this? I'm sorry?
You said I don't want to talk. I just want to be asked. If you asked me a question, I will definitely answer it.
You didn't pay her.
On September 25th at the Secretary of State. And here.
September 30th is when you guys executed this other document. You signed it October 2.
That was when I gave her $500 on October 2nd.
Ma'am.
2 payments.
I don't want to hear it. I don't want to hear it. I don't believe a word you're telling me. I don't believe a word you're telling me. There's nothing here that would add up to you paying $2,000. So if you want to act like I can't add 2 and 3 without a calculator, just you continue doing that. You're late, Mr. Robertson.
Everything was cash, Your Honor.
I wouldn't expect you to, ma'am, you're in a courtroom, okay? I don't want to hear another lie. You're in a courtroom. There's nothing here that adds up to you paying that $2,000 in cash. This was dated October 2 by you. This first page. Is this your signature?
Title is dated 25th of September.
Ms. Bosajur, You come up here. You come up here too. Whose signature is this?
My signature.
Okay. Why would you sign something October 2 saying that you agree to pay $500 per month beginning October 1 with the last payment due on March 1? That would be 6 payments at $500. 6 times 5 is $300. Now you come in with this cockamamie document on the back that you hand wrote and says you paid $2,000 on September 25.
That was the second document that was made up. There's copies.
Quit while you're behind. It's 82-0. There's 2 outs, 2 strikes, and nobody on. Don't lie to me another second. I'm gonna really get it.
The judge systematically dismantled Ms. Hernandez's fabricated story by walking through the timeline of events and highlighting the fatal inconsistencies in her testimony. The critical piece of evidence was the payment agreement signed on October 2nd, 2025, which both parties had signed and which clearly stated that Ms. Hernandez would pay $500 per month beginning October 1st, with the last payment due on March 1st. This would equal 6 payments of $500, totaling $3,000. If Ms. Hernandez had truly paid $2,000 on September 25th, as she claimed, why would she then sign an agreement on October 2nd, just 1 week later, agreeing to pay $500 per month for 6 months? The mathematics alone exposed the lie. If she had already paid $2,000, she would only owe $1,000, which would require just 2 monthly payments, not 6. Furthermore, both parties had initialed the first payment of $500 on October 2nd and the second payment of $500 on November 5th, establishing a clear pattern of documenting payments with initials from both parties. Yet there were no initials, no receipt, and no acknowledgement whatsoever of the alleged $2,000 payment. The only evidence was Ms. Hernandez's own handwritten note on the back of the document, which she had clearly added after the fact in an attempt to manufacture proof of a payment that never occurred. The judge used a baseball analogy to emphasize just how badly Ms. Hernandez's case was going. You're behind, it's 0-2. There's 2 outs, 2 strikes, and nobody on. This was his way of saying the case was essentially over and she had no credible defense remaining.
I told you not to lie to me when you came in here. I told you not to lie to me the other day. I sensed that you were going to come in here and lie to me. I kept an open mind, and here it is in black and white. There's no judge in the country that's going to be convinced that you paid $2,000 on September the 25th. Ma'am, you just decided to fabricate a document here. That's all you did. Ma'am, talk to some other judge, some other place. You're going to figure out right now how you're going to pay her $2,000. You guys, though, Ms. Bozajor, I don't know what to tell you. You just can't do this and trust people. Were you guys friends? Were you friends?
I dated her brother in high school and we were Facebook friends. And she contacted me via Messenger on a social media ad. And I should have never answered the phone. I really should have. I did all kinds of stuff for her.
You're going to go figure out where you're getting the... Hang on. You're going to go figure out where you're going to get the $2,000. Then everybody will be happy. So sit in the back, figure out how you're coming up with $2,000 today.
I got $2,000.
Well, you had enough gumption to come in here and lie to me.
I'm not lying.
You're lying to me, ma'am. I see the title.
That's what?
You're lying to him. There's no way. You signed a document. The one I just showed you. It said that you were going to pay $500 payments starting October 1. And you made a payment on October the 2nd that you both initialed, saying you paid $500. Then you paid another $500 on November 5. Then it's blank. If you'd have paid on October 2 and November 5, the car would have been paid off. There's no indication her initialing anything. This is what happens when things are done in cash. Ma'am, I'm making my ruling. And I'm telling you, I don't know what I'm going to do right now going forward. You're not going to come into this courtroom and lie. Well, you just under oath. That's perjury. Perjury. It's one of the easiest calls I've had in the last 17 years, maybe 31 and a half.
The judge made his ruling clear. Ms. Hernandez owed the full $2,000 and had committed perjury by lying under oath. His statement, "It's one of the easiest calls I've had in the last 17 years, maybe 31 and a half, underscored just how obvious the fraud was. Under Michigan law, specifically MCL 600.1701, judges have broad authority in civil cases to fashion appropriate remedies. In this case, the judge had several options available to him. First, he could enter a judgment against Ms. Hernandez for the $2,000 plus court costs and interest. Second, under the doctrine of unjust enrichment, he could order Ms. Hernandez to return the vehicle to Ms. Bozier since she had failed to honor the payment agreement. The judge mentioned this possibility, noting that he could make you transfer the title over to her because you violated the terms of this purported security agreement. However, the judge expressed concern that this remedy might not be fair to Ms. Bozier as the vehicle may have depreciated or been damaged during the time Ms. Hernandez had possession of it. The third option, and the one that clearly weighed heavily on the judge's mind, was referring the matter to the prosecutor's office for criminal perjury charges. The judge stated emphatically, "That's how certain I am that perjury charges should be filed." This was not a mere threat, but a serious consideration of criminal prosecution. Perjury is a felony in Michigan, and the judge had witnessed Ms. Hernandez lie directly to his face while under oath, with clear documentary evidence proving the lie. He ordered Ms. Hernandez to figure out immediately how she would pay the $2,000 and excused both parties briefly so Ms. Hernandez could make arrangements to obtain the money. However, after the judge excused the parties so Ms. Hernandez could arrange payment of the $2,000, she simply walked out of the courthouse and never returned. The judge waited, had his staff attempt to contact her by phone, and even sent someone to look for her, but Ms. Hernandez had fled. Her decision to leave was not only disrespectful to the court, but also potentially criminal. Under MCL 600.1721, willfully disobeying a court order can result in contempt of court charges, punishable by fines and imprisonment. By walking out after the judge had ordered her to arrange payment, Ms. Hernandez compounded her legal troubles significantly. The judge rescheduled the matter for the following week, stating he needed time to think about what he was going to do. He made clear his belief that perjury charges should be filed, and Ms. Hernandez's flight from the courtroom only strengthened that case. This case serves as a stark reminder of several important lessons. First, never conduct major financial transactions without proper documentation and legal protections. Ms. Bozier's failure to list herself as a secured party on the title and her acceptance of cash payments without receipts left her in an extremely vulnerable position. Second, lying under oath is never worth it. Ms. Hernandez's attempt to fabricate evidence and commit perjury transformed what might have been a simple payment plan arrangement into potential felony charges. Third, taking advantage of someone in a vulnerable state, as Ms. Hernandez allegedly did when she contacted Ms. Bozier shortly after her husband's death, is not only morally reprehensible, but can result in courts being far less sympathetic when disputes arise. As the judge noted, "This pains me to see this," reflecting his genuine sadness at watching someone in Ms. Bozier's position be taken advantage of by someone she had trusted. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.